SJC-12016, Edmund D. LaChance Jr. v. Harold Clarke and others.
Good morning, Mr. Saltzman. This looks like LaChance second chance.
It is my second LaChance case, Your
We're
Honor.
back. Okay. You may proceed.
Thank you, Your Honor. 11 years ago, in the case Mendoza v. Licensing Board of Fall River, this court, quoting the federal decision, the U.S. Supreme Court decision in Farrar v. Hobby, recognized that in order to prevail against the defendant from whom attorney's fees and costs are sought under Section 1988, relief on the merits alone is insufficient. The plaintiff must also obtain an enforceable judgment against the defendant, and in addition, he must obtain relief which directly benefits the plaintiff at the time of judgment or settlement of the case. Against this standard, the award of fees and costs to Mr. LaChance constituted a clear error of law.
If the judge had enjoined the defendants, would it have made a difference?
There are many circumstances in which it would have made a difference. If, under the Ford
The
case...
injunction had entered here, would it have made a difference?
Oh, absolutely.
And that would have made all the, so it's the fact that the judge did not enjoin, because one expects a state, an agent of the state to comply with the law, obviating the need for an injunction, and that gives you then the argument that then there's no entitlement to attorney's fees?
Let me address it this way. What the Supreme Court in Hewitt said is that relief comes through the court, but from the defendants. And when the day is done, it's the relationship between the plaintiff and the defendant that determines whether he has prevailed. The injunction case would be very much like, if I may, the Crawford v. Clarke First Circuit case from 2009 involved segregation inmates who complained that they were not being provided access to religious services. The injunction issued by the court to the defendants was to provide the services through closed-circuit television. With the injunction in hand, even though they were no longer in segregation, they had something that they could enforce against the defendants. They could bring the defendants back to court and say, you're in contempt, you haven't done what the court ordered. The LaChance situation is far different. When the day was done, LaChance had no entitlement to behave differently toward the defendants, to receive anything from the defendants, to require anything from the defendants, to enforce anything against the defendants.
Is it your view that after a LaChance decision, DOC had no obligation to provide a hearing within 90 days for those who were in the SMU?
No, it's not my position at all. The court had spoken and entered a declaration as to what processes do in the situation where you're in conditions that are similar to the DSU, in that you're locked up 23 hours a day, but you're there for a much longer period of time than when you're in on awaiting action in an SMU, and the court said, under these circumstances, there's a liberty interest at 90 days. That's what you got to do, and that's what the department is following through and doing.
Did DOC have that obligation before the LaChance opinion issued?
To
provide a hearing within 90 days.
Okay. This court announced a new rule for the first time, holding defendants qualifiedly immune because no reasonable officer or defendant would have known that. Before that, the department's position was that the process due was the informal reviews stated in Hewitt v. Helms and set forth in our 423 policy. So this court didn't hold our 423 policy regulation invalid. It said, when you get to 90 days, right, you got to do something else.
Okay, but didn't he do that? Didn't Mr. LaChance accomplish that?
The litigation resulted in that, but it did. But the essence of prevailing party status is not that you achieve a result that others will benefit from, but that you have to have a change in your legal relationship with the defendant by operation of judicial imprimatur.
Well, the next time he's been in the SMU, what, 11 times during his incarceration?
He's stated he's been in various times.
So the next time he's in, he will get the benefit of this.
Of course, but the Supreme Court has said that you need to get the benefit at the time the judgment issues, and as the record showed, he was years out of that unit. In fact, he was no longer in maximum security. He had no standing to enforce anything.
This is, seems to me, it's very different from the cases that you, I think, principally rely on, where somebody is either dead or, I mean, he is not released from prison. He is there.
That's right, and the
Keeps going back to await to this status. So I don't know why he is the same as these people who clearly have no connection to the relief once it's given.
Well, you're referring, I believe, Your Honor, to Rhodes v. Stewart, which said that the relief has to benefit the individuals at the time. One was no longer in prison, the other was deceased, but that's the principle that was stated. In order for there to be a change in legal relationship,
But it does benefit him at the time because he's still there.
whether it benefits him is different than whether it results in a change in legal relationship sanctioned by the court. He needs to have something in hand that he can use to enforce his rights. And if I may,
So if going back to Justice Lang's question,
yes.
if instead of saying you do this, and we expect you to do this because government agencies generally are required to do what we do, if we had said we enjoin you to do this, that would have made all the difference.
It certainly would have, because the case law is clear that an injunction changes the legal relationship between the parties.
But
It gives the plaintiff
he'd
something
be in the same
enforceable.
posture as he is now, and that he would not, at least as of the time of when the injunction issued, he would not be the beneficiary of that injunction, at least until he went back into the SMU.
I mean, he's the plaintiff in the case. The injunction runs to him. I think he'd have rights under it, just as the plaintiffs in Crawford had rights to enforce an injunction that the department provide services through closed-circuit TV, even though they're no longer in segregation.
So what I take from this is that we should abandon our respect for state agencies, that they will do what we declare, and enjoin them, because otherwise you get yourself into this ridiculous situation where somebody who has won a victory can't get compensated for it, even though the law allows it.
No, absolutely not. I think courts need to issue relief or not issue relief as the case requires, as equity requires. Facilitating prevailing party status for the plaintiff is not the reason that the case should be adjudicated as it is. It's a federal statute. The Supreme Court has laid down some hard and fast rules. Typically, when you get relief through the court, you're also in a position to get relief from the defendants. But if you don't have that situation, you haven't prevailed, as the Supreme Court has said in interpreting Section 1988.
So you're saying then that if there had been an injunction, Mr. LaChance would enjoy the benefit of it, because if he were to go back in the SMU and were not to enjoy what that injunction demands, he could waive the injunction. And that would be sufficient then to grant him attorney's fees.
That would be sufficient. Other things would have been.
But couldn't he now, if the same thing happened, can't he now waive the LaChance opinion?
No,
and say,
because
no?
he could, but it doesn't make him the prevailing party, that he's able to do something years later. It's a change in the legal relationship at the time the judgment issues. That's what the Supreme Court has said. If you don't have that, you're not prevailing.
But he's in the relation. He's in an ongoing relationship that has been changed as a result of his appeal.
Well, department policy has been changed, but his relationship to the department has not changed. He is not in any position, nor does he have the type of relief which would allow him to say, do something different for me. Had he received damages, clearly he'd be prevailing. Had he been in the SMU over 90 days when the decision came down, he'd be prevailing. In fact, under the Ford case, which has a very generous application of the attorney fee statute, had he, when Judge Murtaugh said 421 applies, had Mr. LaChance been in segregation and we had to apply 421 to him, he would have been prevailing, even though later this court would have vacated that judgment. That's the Ford situation.
So how does your interpretation square with the policy that underlies the attorney's fee statute? I mean, if we were to interpret it the way you say, it would defeat the purpose, which is to have people like Mr. LaChance, private attorneys general, litigating for the greater good.
The Supreme Court has held that not every case where someone achieves some success on the merits is that person going to be the prevailing party. Yes, the purpose is to
Well,
encourage
that's been applied
attorneys.
to a different kind of situation, not the one here. That's been applied to so-called de minimis victories.
There are a few
That's not what we have here.
There are a few situations where you may walk away with something in hand, but you're not a prevailing party. De minimis relief, de minimis damages is one. Having what you want to occur happen, but because of a catalyst situation is another one, where you've put all the time and effort into it, but the state beat you to the punch by changing its policy first. And you can say you catalyzed that, but in Buchanan, the Supreme Court said, no, you're not prevailing. It goes to the essence of the relationship between the parties at the time the judgment comes down. That's a hard and fast rule, and that's what the lower court erred in doing. Just because under the declaratory judgment statute, persons who have standing at the time can enforce the declaration doesn't make Mr. LaChance a prevailing party. You have to have the immediacy, nor can you become a prevailing party retroactively. That's what you would said. If you show up later on and say, well, you know, it benefits me, I'm prevailing, the Supreme Court said no. The essence stated in Hewitt, there has to be that change at the time.
If we don't agree with you, can you give me an example of a case that would be, that could flow from our decision, that would be legally untenable or create significant problems?
I'm not quite sure what you're aiming at.
What are the downside risks of our holding against you?
Well, you would be, frankly, it would be a holding that's inconsistent with Supreme Court.
Well, besides that.
Besides that.
What are some of the practical consequences that could befall a decision that goes against you?
We would have a state court decision that's inconsistent with Supreme Court decisions that awards public funds to people who don't meet the statutory requirement under Section 1988. The court has said, you know, these are public funds, and when you pay them out for attorney's fees, although, you know, for a good purpose, you are depriving the government of money that it could be used for something else. These decisions have to be made carefully and in accordance with the Supreme Court case law.
Apart from that, is there a disincentive created to any party or in the future to behave in a way that we want them to behave?
Counsel for the Department of Correction for 30 years defending litigation from all sides. I doubt there's going to be any disincentive as time goes on.
Pragmatically, if you're right, virtually anybody who challenges their solitary confinement is not going to get attorney's fees,
No,
unless they happen to be held in solitary at the time that the judgment issues.
Any person to claim prevailing party status has to point to an enforceable change in legal relationship. For example, in the Mendoza case, the plaintiff was successful in invalidating a municipal ordinance that prevented nude dancing. He was then in a different relationship with the municipality because he could pursue a variance to open an establishment. There was a change in legal relationship.
Okay, well, let's focus on solitary confinement. Tell me when somebody who's challenging the due process of their solitary confinement would be able to obtain attorney's fees under your theory.
To obtain attorney's fees, you have to achieve an outcome that's enforceable by you at the time. If someone
Which means they'd have to be in solitary at the time.
Or if there was
an
money
injunction.
damages? If there was money damages, would that be enough?
Or an
Damages,
injunction.
an injunction. There are more ways to be a prevailing party than not be a prevailing party in the law.
So in the future, whenever a matter comes, we should order an injunction as opposed to a declaration that you should do something, and that
Exactly
would
right.
then, that makes
Absolutely
all the
not.
difference.
Absolutely not. The court should continue to rely on the government
Why?
to do the right thing. Because
The
the
government,
attorney, Your Honor,
would the right thing not be to pay the $28,000?
that's only payable as an exception to the rule that each side bears its own expenses by virtue of a federal statute. The attorney fee result should never be the driving factor in a court's decision on important issues of any sort, or on
What is-
any issue of any sort.
I'm sure there are cases, but could you just tell me cases in terms of the issue of capable of repetition yet evading review? Because, I mean, you can see, I'm not saying that's the case here, but you can certainly see that an agency can just pick off the people and make it impossible ever to prevail.
Well, in terms of attorney's fees, the question is, was the relief moot?
No,
not
but
whether
just
the
cases, federal cases about, which raise the issue of capable of repetition yet evading review.
Let me use LaChance, the first case, as an example. LaChance was long out of segregation. It was a damages case. This court used the opportunity to announce a new rule describing what procedures are required in this unexplored territory that was neither a DSU nor short-term awaiting action. Nothing prevented the court from reaching the ultimate conclusion. The case, Mr. LaChance was not in segregation, but the case was not moot. It was fully adjudicated.
Let me ask you one last question. If you do not prevail in persuading us that he should not get his attorney's fees, the $28,000, would he also be entitled to the attorney's fees for litigating this matter?
He could seek appellate fees as a successful appellate litigant. That's a separate matter. It's not under Section 1988.
Okay, thank you.
Thank you.
Very good.
Good morning, Chief Justice Gantz, members of the court. My name is Jim Pajon, and I represent the plaintiff appellee, Edmund LaChance. Mr. LaChance achieved a significant victory by obtaining an enforceable judgment that declared for the first time that the United States Constitution prohibits the Department of Correction from confining him or any other prisoner in administrative segregation on awaiting action status without substantial due process safeguards. Despite his victory on the merits and the defendant's failure to appeal the judgment, the defendants have argued that Mr. LaChance is not the prevailing party because the original judgment issued by Judge Murtaugh in the Superior Court, the opinion of this court in LaChance, and the final judgment issued below were all moot when entered and therefore did not afford Mr. LaChance any relief.
Mr. Pajon, I obviously did not explain myself very well to your, Mr. Salzman, but this is the question I'm asking. Are there federal decisions involving attorney's fees decisions where the particular plaintiff is, it's moot as to him, but it has been litigated as a capable of repetition yet evading review, and therefore, what has the federal court done with that in terms of attorney's fees?
Well, I think that there aren't too many reported decisions on that kind of a question because the answer is obvious. If the matter is capable of repetition, the plaintiff is deemed to have a sufficient stake in the outcome of the case such that the court decided the case instead of dismissing it. And the rule in terms of attorney's fees is, yes, you can't just win a pure, raw declaratory judgment. There has to be some benefit to you. But the threshold for deciding what that benefit is extremely low. In the Farrar case, for example, the Supreme Court said that an award of nominal damages of $1 automatically makes the plaintiff the prevailing party, even though in the real world that's just a moral victory. So the threshold is really low. The question is, to get attorney's fees, did you receive some benefit? So going back to your question, if a case becomes moot or arguably moot and the plaintiff says, well, this could happen to me again, I am at risk, and the court agrees with that and decides the case in that situation and decides it in his favor, in that situation, well, he has won. he has won something that is meaningful, otherwise the court would not have agreed to decide it, and therefore the question of whether he's the prevailing party or not is pretty much already decided. And so I looked for cases where the defendant objected on that kind of ground, and there aren't many, but I looked a little deeper and looked into Pacer and things like that. Well, what happened? Well, they got their fees, because it's really the only question there is how much. So, the whole notion of mootness in this case doesn't really apply, because mootness is usually a doctrine that comes up when the court has to decide whether or not to decide the case. Here, the case was decided. So the only sort of aspect of mootness that really makes any sense here is the notion of capable of repetition. Is there a sufficient risk that the harm that was challenged or the plaintiff was concerned about might happen again, such that he has a stake in the outcome such that the court should decide it? And so therefore, there are a lot of cases like that where prisoners...
But then why is Rhodes different?
Well, Rhodes is different because in that case, the prisoner was dead or out of prison.
But the court declared that they were entitled to the magazines.
Yeah, so and I think that the court, looking back on it, the Supreme Court clearly felt that that was an error, that the lower court should not have decided that case. But what and so all of these cases are very fact dependent, and I think it's important to keep in mind that the question of whether or not Mr. LaChance received a sufficient benefit is a fact question. And there are cases that say that. And I didn't make that point in my brief, but there's a case, a Seventh Circuit case, Southworth 376 F. 3rd 757, where the court says very clearly that the question of whether the relief is sufficiently beneficial is a fact question, and we can't overturn the lower court's decision on that absent clear error. So here...
That would be Judge Cornetta's decision.
Justice Cornetta decided that Mr. LaChance benefited from it, and for all of the kinds of reasons that Justice Lank and others of you were pointing out, that you don't need an injunction. And in fact, Mr. Saltzman in his brief sort of makes that point. He says that Mr. LaChance is not in danger of being treated unconstitutionally again. And the reason that he's not in danger of that happening again is because of LaChance, that LaChance stands as a shield between him and similar unconstitutional conduct. Again, that is a benefit. That's an immediate benefit that he has as soon as he got that declaratory judgment. What happened to him won't happen again, or theoretically won't happen again, because he has a judgment that is enforceable. And in the Ford case, it's interesting there, because there the court issued a number of declarations. One of them was that Mr. Ford had been denied procedural due process when he was placed in the DDU as a sentenced prisoner for conduct that he had engaged in under a prior sentence. And the court also issued an injunction saying that the DDU sentence that he was being forced to resume was void. And the First Circuit said, well, that injunction was moot when it was entered, so we're going to vacate it because it was moot because he was out of the DDU at that point. But the court also said that even though there might be some risk that he would go back in the same circumstances, he was protected by a declaratory judgment that said that that would violate procedural due process. And the fees, he was awarded $140,000 in fees on remand, and those fees were for the work he had done in achieving that judgment, the declaratory judgment. So it wasn't the injunction was vacated, but he still got fees based on the declaratory judgment that said that that conduct was unlawful. So I don't think you need an injunction, and I think it would have all of the the kinds of untoward effects that you were concerned about. And I don't think Mr. Saltzman wants injunctions when the department is putting forth a view that it's going to comply with a declaratory judgment.
Now, would it have mattered if he had been released before the judgment issued?
If he had been released entirely from prison, I think it would have mattered, yes, Your Honor. I think that's a different case. That's a case
That's a
where,
Rhodes
I mean,
case.
it also gets complicated too, because the law is that if it becomes moot during the course of an appeal, you can still get fees, even if the court vacates the underlying judgment, if it wasn't moot at the time it was issued. But if he had been released back in 2007 from prison, but the case had gone forward on the damage claim or whatever, yeah, that would make a big difference. So these cases are very, very fact-dependent, and we're not arguing that a prisoner who has been released from custody and yet wins a judgment has received a sufficient benefit from that judgment to make him the prevailing party for fees. No, I think that's a different scenario altogether. But these scenarios vary a lot. Like in Crawford versus Clarke, the prisoners, as Mr. Saltzman pointed out, were no longer in segregation. Yes, they got an injunction, but you could certainly have argued that they didn't benefit from that injunction because they weren't in the conditions to which the injunction applied, but they still got fees, and they got fees because the court had said, even though they're no longer in segregation, they've been in segregation before, we're going to decide this case, and had issued a department-wide injunction, and they happened to be the two prisoners who brought the case, and they got the fees because they won, and the injunction is considered sufficiently beneficial to them because of the possibility that they could go back to segregation. And you know, the defendant's sort of argument that that a prisoner who is not directly, immediately affected by the judgment at the moment that it issues, you know, sort of flies in the face of the notion that you can receive a benefit when you're protected from a significant enough risk of something happening to you in the future. So, like you were saying, you know, just because you were out of segregation, if you're in and out all the time, and there's a significant enough risk that you might again go back, you know, that's sufficient. That's sufficient to make the case not moot for purposes of a judge deciding it, and it would be sufficient to award fees if the judge did decide it in your favor. If there aren't any questions on the prevailing party, I'll just say a word about the amount of the fees. The $28,000 you know, we submit as a very modest award for quite a lot of work. And the defendant's argument there rests pretty much entirely on the fact that Mr. LaChance was unable to persuade this court that as a matter of federal due process, he was entitled to the protections of the DSU regulations. But nonetheless, he achieved a very significant victory, you know, that applies not only to him, but to all other prisoners. And if you sort of look at this case sort of in the abstract and you ask, well, what if he had never sought the DSU regulations? What if he had just sought what he did in fact get as a matter of federal due process? Would that be a significant win? It absolutely would. It forced the Department of Correction to adopt new policies that provide significant safeguards to prisoners, maybe not as much as we would like, but still significant. And it forced the department to acknowledge that there is now a liberty interest that prisoners have in not being placed under these kinds of very harsh conditions. That was something that they had contested vigorously. So I think he won a significant victory, even though he didn't win everything that he wanted. The other issue is whether or not the time spent on the argument with respect to the DSU regulations was involved sufficiently with with the claim that he was successful on with respect to due process, such that they share a common core of facts and related legal theories.
Did the judge cut, I mean, that was the principal reason that he reduced it, isn't it?
The principal reason that he reduced it was that we didn't win on the DSU claim.
Right.
And you know, I think that he
You're not
reduced it too much.
contesting that
But
here.
You
didn't
know,
appeal.
Attorney's fees litigation is not how I want to spend my time, Your Honor. So we did not cross appeal. I think he was within his discretion. He has very broad discretion. So no, but I think that he was also within his discretion in deciding that the claims and the legal theories were sufficiently interrelated such that Mr. LaChance could be compensated for the time that he spent working on both cases. And to reduce the award by anything more than that, in our view, would both sort of denigrate what this court did in LaChance. It would be inconsistent with the purposes of Section 1988, and as the Supreme Court said in Buchanan, if private citizens are to be able to assert their civil rights, and if those who violate the nation's fundamental laws are not to proceed with impunity, these citizens must have the opportunity to recover what it costs them to vindicate their rights in court. If there are no further questions,
Am I correct that with regard to your entitlement to fees, that's a question of law?
yes.
But with regard to the amount of fees, the standard is abuse of discretion?
Yes, but with respect to the first question, I
But
think it's
the
also
issue of
abuse
fact
of
from Judge Cornett.
That's right.
Gotcha. Okay, thank you.
Thank you.